The purpose? It was proposed that beyond a certain point, society needed to be able to take stronger measures to protect itself against these top-end offenders, and that young offenders who committed serious offences should be held accountable for their crimes more in the same way as adult offenders. The intention was to target the top-end serious repeat offenders, not Cindy Kerou's Morrow bar stealer, not the Morrow bar stealer. That was a ridiculous analogy by that woman. The means by which the bill sought to achieve these aims was to change the legal position with respect to age of criminal responsibility to 10, broaden the circumstances in which young offenders could be sentenced to incarceration to include cases where offenders were convicted of serious offences, and we went on to define that, move children and young people aged 10 or over who commit serious crimes offences to the same category jurisdiction as those who commit murder, manslaughter, the district court, define a serious offence as any offence for which the maximum penalty is imprisonment for a term of not less than 3 months or a fine of not less than $2,000. Now, we thought, Madam Speaker, in our innocence, that if you went to jail for 3 months, you had committed a serious crime. Well, it appears that people in this House don't think that. We accepted in time, and I'll cover that, some of the criticisms, and we indicated a desire to take an amendment. The consequences, well, the advice from the officials has highlighted a number of consequences with respect to the bill's impact on the youth court and lower level offenders, and indications are that if the bill were to proceed in its current form, neither of the two major parties represented in the committee would support it at the second reading, something they've said they won't do. New Zealand First has always said its intention is to improve and enhance the youth justice system as it applies to young persons, and to better equip the New Zealand Police that they can intervene more effectively with persistent and serious young offenders. New Zealand First wishes to preserve those aspects of the youth justice system that are proving effective, but to amend those that we believe are not effective. Madam Speaker, it had been my intention to read out this letter because this letter was tabled to the Select Committee and clearly lays out all of the amendments that we were prepared to accept. I'm going to seek leave to table that so that the House can see precisely the extent of amendment we were prepared to accept in the Select Committee and in this committee stage to achieve some of the things that notably Mr John Key said he wants to achieve in his latest speech, such as widen the jurisdiction of the youth court and widen the sentencing range available. I'm going to also seek leave to table this. This is the RT that was drafted by PCO to achieve these amendments. An RT, an amendment that could have been passed by the Select Committee and brought to this table as an amended bill. One of the committee members said to me, "But Ron, this guts your bill." My answer to him was, I left my ego outside the door. The aim is to improve the youth justice system. It saddens New Zealand First greatly that the opportunity to take these amendments, put them into the bill and present this newly amended bill to this table has been thwarted by Nationals and Labor's refusal to accept these amendments drafted by PCO. We think that is a perversion of the democratic process and a perversion of the Select Committee process, and we are not happy. I will seek leave to table this. Let's be clear, these amendments produced at the Select Committee would have achieved everything that Mr Key says he wants to achieve. Widen the jurisdiction of the youth court, not shrink it. Enhance the sentencing options available to the youth judge, not restrict it. To broaden the definition of serious offending or to make it stronger, more acceptable to the two major parties, and to ensure that young offenders did not go to jail but went to a youth detention facility. We're saddened by that, and I seek leave now, Madam Speaker. Point of order.
Point of order, Ron Mark.
I seek the leave of the House to table PCO S 7176/3, the Young Offender Serious Crimes Bill, proposed amendments for the consideration of the Select Committee.
Leave is sought to table that document. It is granted.
I seek the leave of the House to table a letter from myself to the members of the Law and Order Select Committee, Parliament Buildings, Wellington, on the 16th of October, outlining New Zealand First's ultimate intention and our willingness to accept amendments to definitions and the bill to make it more workable.
To table that document. Any objections? There are no objections.
Thank you.